Welcome to Red, White, and Blue. From the right, I'm Gary Polland.
And from the left, I'm David Jones.
Tonight we welcome the candidates for Texas Attorney General. First, the incumbent Republican Attorney General Greg Abbott. Second, Democratic candidate Barbara Ann Radnofsky. And third, Libertarian candidate John Rowland. Welcome to y'all.
Thank you for having us.
Great to be here with you. You must be happy the Houston Chronicle endorsed you. Why don't you use the Chronicle endorsement and tell us what two things you're most proud of as you're seeking re-election to Attorney General?
Well, I think the first and foremost duty of an Attorney General, in fact, the first and foremost duty of government, is to keep people safe. And I have, as Attorney General, arrested more criminals than any Attorney General in Texas history. The way that I've gone about doing that is by creating some new programs. I created a new program that we call the Cybercrimes Unit. What the Cybercrimes Unit does is to focus on child predators who use the internet to prey upon children. With the new technology age, child predators don't lurk behind trees at playgrounds or at schoolyards or at malls as much as they used to. Instead, what child predators are doing, they go on to things like Facebook, to Yahoo chat rooms, different locations like that, and they literally target the child they want to be their next victim. And so we set up a unit where we have investigators who log on to those same internet chat rooms, those same locations that the child predators use, and these investigators from my office assume the identity of a 13-year-old girl. And soon they are bombarded with language and propositions from these criminals who set up a time, date, and location where they show up to sexually assault what they think is a 13-year-old girl. I've been there before and I've witnessed it. They are astonished when they find the person they're meeting is not 13-year-old Amy, but a 35-year-old investigator from the Attorney General's office who puts handcuffs on them. In addition to the Cybercrimes Unit that we created to crack down on child predators, we created a fugitive unit. What the fugitive unit focuses on is tracking down and arresting previously convicted sex offenders who are out on parole in violation of their parole, and our job is to get to them before they get to their next victim. We all need to understand there are certain criminals who are at a higher rate of being a repeat offender, of being a recidivist. Statistics show that a category of that kind of criminal are especially child predators. Well, we set up this operation in Austin, Texas, where we would get information on a daily basis about the kinds of criminals who would fall into this category, and then we would use good old-fashioned investigative tools to crisscross the state of Texas to track them down and arrest them. Well, that program proved so successful that in the following legislative session, the legislature authorized my office to create satellite offices to perform this task. We created one here in the greater Houston area. We created one in the greater Dallas-Fort Worth area, and we have one in the central South Texas area. Altogether, I've arrested more than 2,000 dangerous criminals, gotten them off the streets, and I've been involved in getting indictments from everything ranging from capital murder crimes to bribery across the state of Texas.
So he's doing a good job of keeping you safe, Mr. Radnofsky?
Stings are a great idea. I'm glad he caught 2,000 people. We need a comprehensive approach to crime in this state, and we need to have the money within which to have the programs that Mr. Abbott has lately implemented. Stings don't solve the problem of cybercrime. The FBI has a comprehensive approach starting in the schools. And we must not just limit ourselves to trying to have sting operations to pose as 13-year-olds. Good idea, won't solve all the crime in Texas. The FBI's approach includes comprehensive programs in the schools, several different kinds, where they teach children and teachers. You can't just rely on mom and dad at home supposedly supervising the kid online. And there are wonderful programs available, and as Attorney General, I will emphasize those learning and education programs together with some of the good programs that AGs all across this country have adopted. But you need the money to do it. And the problem we're facing in this state is that the AG can't go back to the legislature every time he has an idea for an innovative sting operation. What we need in this state is an answer to our $18 to $21 billion shortfall so that we can fund anti-crime measures.
And that answer would be what?
That answer exists within the power of the Attorney General to fight Wall Street fraud, which has cost this state just with our 10 major investments in this state, including the Permanent School Fund, $35 billion between 2007 and 2009. Wall Street fraud cost us tens of billions of dollars. We can recover those funds if we're willing to fight Wall Street, not with fines, not with penalties that are never paid back to Texas, and not with voluntary systems of foreclosure that will stave off foreclosure if people voluntarily comply, which is the part of a problem that was caused starting in 2008 and before.
Well, I want to ask John this. John, you've heard Barbara talk about educating children, cybercrime and the like. You want government in your house observing and supervising what you do on the internet?
Definitely not. All of these efforts sound great, but they're flawed at several levels. For one thing, a lot of these things are not going to bring convictions because there are evidentiary problems with them. So certain kinds of stings can be useful, but you want to make very sure that the offender really knew that he was committing a crime, that he had mens rea. So
you're in a libertarian party.
That's right.
What is a libertarian legal system going to look like with you, Attorney General?
Well, first of all, the Attorney General, of course, doesn't make the legal system. He only gets to work within fairly narrow bounds. What I would do as Attorney General is focus on local public corruption. We are generally aware of how bad it's gotten in Mexico. The problem is that what's happening in Mexico is spreading to the United States, and in particular to Texas. And I know of many cases where local people are aware of corruption in their cities and counties, and they don't feel that they can go to the authorities because they're all complicit. So one of the things I would do as Attorney General is to open grand juries to complaints by citizens of bringing evidence of such corruption and arrange for the appointment of special prosecutors when perhaps the local DA may be compromised.
If I could respond to a couple of things that John mentioned. First, with regard to cybercrimes, what he basically raised was the issue of entrapment. And he said, what's important is not the arrests, but the convictions. And I'm proud to say we have a 100% conviction rate. The issue of entrapment has been raised by some of the people who've been charged with these crimes, and they have lost every time they raise the entrapment issue because we follow procedures, frankly, that are consistent with procedures that are laid out by the FBI.
But I want to ask you this is related to that, though, because part of what you're doing with the cyber crimes and catching people by surprise, has the word gotten out among the predators of 13-year-old girls that you never know who you're talking to on the internet?
It has. We actually have a tape of that because one person that we were chatting with said, and we have this recorded, that, listen, we got to be careful here because, the Attorney General is looking into this. And so the word is getting out, and that's one of the reasons why we do that. But in addition to going about the process of arresting these people and convicting them, we also work programs across the state of Texas at educating both parents and, most importantly, teens about these dangers. But I also want to follow up on the other point that John mentioned because I think it's a good and valid point, and that is the issue with regard to legal violations that some public officials may have engaged in. As best as I can tell, I have prosecuted more public corruption crimes than any Attorney General in Texas history.
But what about Wall Street corruption? That's what Mr. Rodnofsky is suggesting you've defaulted on. I mean, what can you answer that?
I would like to hear what's going to happen.
Sure.
Why aren't we suing Wall Street? Why aren't we fighting Wall Street? We could recover tens of billions of dollars. I'm not talking about
I haven't
criminal.
heard you say that he has contributions from Wall Street people that are keeping him from taking these actions.
He has more than $2 million of contributions from not only Wall Street interests, but from Wall Street entities that have already been charged by the SEC or by state securities authorities. $2 million.
But they're all legal contributions, right?
The interests are preventing Mr. Abbott. I'm not accusing Mr. Abbott of illegal campaign receipts. I am saying that his donors, from a gentleman who has his campaign slogan, "Don't tread on me," I believe his campaign slogan should be, "Don't tread on my donors," because this gentleman has a history, with all due respect, of decision-making that paves the way for his donors to continue their practices.
So that's a different issue. Because
it is a different. I'm not accusing him of any illegal.
Let me respond to that, though, in two regards. If I could, we could backtrack 5 minutes ago when David asked me the question. I didn't have the chance to answer, which I will. But first, let me respond to the comment made by Barbara. As you all know, the integrity of my decision-making process began when I became a state district judge here in Houston. When I was a state district judge here in Houston, I was the highest rated state district judge as determined by the Houston Bar Association. Then I went on to become a Supreme Court justice. As a justice on the state's highest court, once again, I was the highest rated justice. The reason why I was recognized as being so well regarded, if you look in the subcategories of the way people voted in those polls, part of it was the integrity of my decision-making process. When I was a state district judge and a Supreme Court justice, people like Barbara Radnofsky and her firm consistently donated and supported my campaign. Sometimes I ruled for her firm, sometimes I ruled against her firm. Every time I made a ruling as a state district judge and as a Supreme Court justice, it was based solely upon the law. And the reason why I use that as a predicate is because I have brought to the Attorney General's office the same legal decision-making process that I employed as a state district judge and as a Supreme Court justice. And that is to base every decision I make on what the law is. And then getting back to your question, we have been going after financial institutions of all different kinds for several years now. It began, first of all, with the lawsuit against Ameriquest. And let me frame this first of all. The financial challenges that we have dealt with in the last couple of years have been primarily because of the real estate industry and because of financing involving the real estate industry. We began our legal challenges initially against Ameriquest, in which we have settled for. We continued legal challenges against Countrywide, which was later taken over by Bank of America. As you notes probably show, we just settled last week with Wells Fargo for one of the claims. But importantly, David, is this, and that is that I am on the steering committee of a multi-state attorney general group that's looking into the practices of all of these financial institutions. And we are considering a variety of different kinds of legal challenges. I've read what Barbara came up with, and I got to tell you, the validity and strength of the legal challenges that we are evaluating is far superior to the new kind of novel legal ideas that she's talking about.
I should be entitled to respond to that.
Sure, go ahead.
It's absolutely false. What I have proposed is backed up by deans of law school, professors, former state bar presidents. It is based on the same legal theory. It's been around for 100 years, called quasi-sovereign interests. It has been successfully used in other cases to recover billions of dollars, including the billions of dollars recovered for Texas and its health in the tobacco settlement. This case is straightforward.
Well, I would think you would be more interested in Mr. Abbott's declaration of the integrity of his decision-making process.
I am interested in both, but I must come and say that if our interest is in the economic well-being of Texas, the reluctance of Mr. Abbott to make the kind of lawsuit I'm talking about, which would bring $35 billion or more back to Texas, is far more important than his personal opinion of his personal attributes. This is not a personal thing. Mr. Abbott, as Attorney General, has greatly disappointed us, me, friends at my law firm, in terms of how he has comported himself. That doesn't matter. What matters is who would be the better leader for Texas in terms of the AG's office. Examples I will give you, because I should be entitled to at least one.
Well, I think
Bob Perry of Bob Perry Homes gave $100,000 to Mr. Abbott within 24 hours of a request to Mr. Abbott for a decision which ultimately went in favor of Mr. Perry's influenced Texas Residential Home Building Commission, which was eventually sunsetted by the legislature. I fault the decision-making that Mr. Abbott engaged in that decision, as well as the donation of $100,000, part of more than $1 million that Mr. Abbott has received from Bob Perry and that giant. The same is true of decision-making, which I believe has been influenced in a whole series of matters. It's not just $2 million from Wall Street interests. It involves hundreds of thousands of dollars from special interests.
Well, all legal donations, every one of them under Texas law.
I'm not accusing him of Tom DeLay type tactics.
Democrats
I am not.
take big checks. Bill White's taking big checks from trial lawyers. I mean, the question
decision making within 24 hours, being asked for a decision within 24 hours makes it pretty darn clear.
But her only point, the bigger point.
There are many examples.
Let me just say, no, you can answer. I just want to say, this is not the bigger point that she's making, is that Rick Perry needs help from his Attorney General. And I think the press releases that I've seen says that, I mean, you would concede that Rick Perry asked you to sue on his behalf the federal government, Department of Education, to enforce his views of how $830 million coming to Texas school children should be spent. Fair?
Well, strings are not strings, but...
Yeah, I mean, he asked you to do that. He asked you to take a political position in that lawsuit against the Department of Education.
Hold on a second. This wasn't a political decision. This was a legal decision. The reason why it's a legal decision is because of something, frankly, I've never seen before. And that is the United States Congress passed a law that applied to 49 states. And they had an amendment that made a different law that applied to the state of Texas. Under that law, 49 states had access to what are called EduJobs funding. Those EduJobs funding were funding for teachers and educational purposes in 49 states. Because of an amendment that was put on by Lloyd Doggett, it set up a
congressman from Austin.
Democratic congressman from Austin.
It set up a requirement in Texas where the governor, in order for the state of Texas to receive this funding, had to make an assurance that violated the Texas Constitution, which made it so that Texas, and only Texas, was denied this funding for this year. Now, that assurance can be made next year, but not this year, and let me explain why.
But don't they have a...
Isn't it responsible given that... You have not let me finish the explanation.
We didn't spend the $3.2 billion in the previous cycle.
David, no, that's factually incorrect. That is factually incorrect. Because Texas did get $3.25 billion from the feds in 2009. And all of that money was spent on education. 100% of it was dedicated to education. That's an absolute fact. Anyone who pulls out...
You need to point out that what happened to the other money that was in our education fund. What happened to our money?
If you let me finish, education funding in Texas increased, and 100% of the education dollars went to the state of Texas. But here's the important part, because this is the legal issue which Barbara and I have drawn a line on, and which we disagree on. What happened is that with the original funding that Texas received, the governor made an assurance over a 3-year period, beginning in 2009 for the periods of 2009, 10, and 11. He was able to do that because the 2009 budget was already in existence, and in July of 2009, when he made the assurance, the appropriation for the following 2 years had already been made. What happened this time, and the reason why Congress set up a standard that's unconstitutional for the state of Texas, is they set a standard now requiring the governor to make assurances 3 years in advance concerning a legislature that hasn't even been elected yet to pass the budget.
Well,
let me just tell them what happened when you talk. Tell them what happened to our money that was our Texas taxpayer money, the $3.2 billion that got siphoned out. Tell them about it.
My point first. The dogged clause violates two provisions of the Constitution, the Equal Protection Clause of the 14th Amendment, and, interestingly enough, the General Welfare Clause, which is a restriction on taxing and spending, not a delegation of power. But what is also not delegated by the U.S. Congress is any authority to give money to the states for education unless it's connected to militia, for militia training. If it's not for militia training, the federal government, Congress, has no business giving it to us, and we have no business accepting it.
I wonder, let me just say, because neither of these gentlemen will. Governor Perry took our money that was in the education fund and siphoned it out and replaced it with the federal stimulus money. That was special money that was supposed to be used for education. Instead, it was used later by Governor Perry as a substitute for the money he took away from us.
Well, that was the legislature that passed that.
Well,
actually.
let me say, it clearly was Governor Perry's intention. Now, the fact that you just said it was the legislature that did that proves the incorrect argument that Mr. Abbott makes, which is when Governor Perry signed the first application in 2009, Mr. Abbott says that Governor Perry could do so because there would not be legislative activity that would thwart what Governor Perry did for 3 years. In fact, what happened was the governor and the legislature were able to act despite Governor Perry's assurances. From a legal standpoint, that was foreseeable. As a matter of fact, I believe that these folks were in cahoots. I believe that Governor Perry and Mr. Abbott knew what was going to happen, and therefore, Governor Perry's initial assurance could not have been made.
Were you in cahoots with Rick Perry whenever you sued on behalf of the state of Texas to enjoin the enforcement of the health care tax?
Yeah, 2 points. There are no cahoots.
There are cahoots.
I base my decisions based upon the law, regardless of the policy positions that Barbara wants to take. And I assume that she really believes in them. I'll tell you, for one, they're factually incorrect. But that point aside, the issue is whether or not, kind of as John pointed out, whether or not Congress can pass a law like this that violates the United States Constitution. The job of the Attorney General is to wage those legal challenges. And it's up to the legislature to make the policy decisions about how they're going to spend the money. The way this spending bill came out of Washington, D.C. was just one of a multitude of ways in which Washington has been trampling the United States Constitution, violating our rights, targeting Texas, and in doing so, hurting Texas jobs, hurting Texas economy, causing, in this case, teachers to get laid off, in other cases, causing people who work at refineries around here in the area of Houston to get laid off, causing people who work in the oil and gas industry to get laid off. The Obama administration has done more to destroy jobs, to hamper our economy, and the Congress has done also.
Wouldn't you agree with me that 2 district judges, federal district judges, have said that your position in your friend of the court brief with Arizona's immigration law, it went the other way. In your lawsuit against the federal government for the tax on the healthcare system, the district judge in Detroit said it's constitutional, also disagreed with your position.
Well, hold on a second, because the first judge to rule upon it was the federal judge in Virginia. What that federal judge in Virginia ruled is that when the federal government came in and said, oh, this case is without merit, it should be tossed out, the federal judge in Virginia said no. This is a valid claim that deserves to move forward. In the Texas lawsuit, the one that I filed, an hour after Barack Obama signed the health care reform bill that forced all Americans to go out and purchase health care insurance, I filed a lawsuit along with 12 other states in Florida. And that lawsuit had its first hearing on September 14th. In that hearing on September 14th, the judge considered the federal government's motion to toss that case out of court based upon the federal government's contention that it was without
Barbara,
merit.
close it out on this issue of the health care thing.
These are a series of initiatives by Governor Perry and the gentleman acting as his consigliere. Mr. Abbott should not be Governor Perry's consigliere. He should be acting on behalf of the people of Texas. The health care legislation that was challenged was the result of significant congressional findings that have already been upheld by one court. We will be in litigation over this matter for a long time. It cannot be settled. It is a show lawsuit. The specifics of whether or not the government can tell someone in Texas how to act was decided under the Commerce Clause in a very famous case called Heart of Atlanta Motel.
And you can read that and Google it anytime you're ready.
Because you
Thank
cannot
you, Mr. Rowland.
you can't prevent a restaurant
We could have
from
got an
serving
hour,
blacks.
David.
Thank you, Ms. Rodnowski. Thank you,
Thank
Attorney
you.
General Abbott. It's great to have had you. We couldn't get them to sit down together. I'm talking about Bill White and Rick Perry, but you can see that if you'd like by watching Evan Smith of the Texas Tribune for extended interviews. You can watch that by going to our page at HoustonPBS.org beginning Monday, October 18th. And until next time, get informed and get active.